How should campuses respond when online campaigns target faculty, students, or invited speakers? Does reputational risk justify any restriction of expressive activity?
This is an area that we've seen ramp up significantly in the last few years, in particular. And so, the first thing I would say is just from an institutional perspective, doing your best to support that are targeted by the speech. Sometimes the speakers have no affiliation with the university whatsoever, so you're not even really worried about discipline because you can't. It's more about providing maybe counseling resources, providing additional security patrols if needed, if there's a serious issue. Of course, if there's a threat, helping them report that to law enforcement is important. Other little practical things are helping individuals understand how to block someone on social media. We've given those lessons before. How to make your own accounts private or remove those personal details so that they're not out in the public domain. And then you can look at one thing on that before I move on to the next piece that I always want to emphasize is making sure that the institution is setting realistic expectations. And so what we sometimes see is we've had a situation where faculty was unfortunately targeted by some issues, and the student that had posted a video or made a comment in this video, the statement was made, well, that student should be suspended. Well, that was protected speech for the student. We can't suspend that student, and it set the institution up for failure from the outset. And so being realistic about what you can and cannot do at the institutional level is really important. As to actual discipline, you have to look to what Mackenzie touched on earlier, the severe, pervasive, and objectively offensive analysis, and make sure that if it is an institutional actor engaging in these behaviors, that before you take action, you're going through that analysis. It's a difficult standard to meet, the harassment definition, because you have to show that you're actually denying access to an individual's education. So that's a really, really high bar to meet. The bottom line is reputational risk alone isn't going to legally survive a First Amendment claim. That doesn't make the decision any easier when you're the administrator sitting in the hot seat making those decisions. And so it's a really challenging place to be. But to legally take action, you'll have to go back to showing the disruption that we've talked about throughout the answers to the questions that led up to this one.
Well, thank you. And this may be somewhat of a follow-up question, but if a student organization, Mackenzie, invites a speaker and later rescinds the invitation due to an internal disagreement, are there free speech concerns? And does the institution itself have any role in that analysis?
So when a student organization invites a speaker and then uninvites them due to internal disagreements within the organization, that is generally a private, protected exercise of that organization's own freedom of association. And expressive associations have a constitutional right to control their own message and choose who speaks on their behalf. The First Amendment constrains government action. And a student organization, even one that's recognized by a public university, is generally not itself a state actor when it makes internal programmatic decisions. So when a student organization invites and then rescinds a speaker's invitation due to an internal disagreement, at least in the first instance, that's a private associational decision, not a government action. But free speech concerns tend to erupt when the institution perhaps pressures or coerces or forces a student group to rescind the invitation because the institution itself is a little concerned about the speaker's message. And the First Amendment questions arise when you ask what role, if any, right, the institution played in that rescission, and whether institutional resources, policies, or pressure were involved. Where the institution needs to be really careful is when the university is the one pressuring the rescission and when it administers recognition, funding, or space on a viewpoint discriminatory basis. And that's really where Christian Legal Society versus Martinez potentially becomes relevant. The university has to administer its foreign policies in a viewpoint neutral and reasonable way. Now, there are no constitutional provisions that require a public university to say, compel a student organization to host a speaker the organization doesn't want, or to provide its own platform or resources for every speaker a student invites, or to override an organization's internal decision-making process. That, in fact, is their own decision. Or to ensure that every invited speaker by a student ultimately appears on campus. So the institution's role is usually not to force the invitation back into existence, but to ensure that it itself does not discriminate or coerce based on viewpoint.
Okay. Sometimes there are legitimate security concerns. How should institutions determine security measures without effectively pricing out controversial speakers. What should institutions be thinking about regarding security fees and compliance with SB 1725?
Yeah, so this is in light of recent events, institutions are on notice of the serious security concerns that can accompany some of these speakers coming to campus. So at the federal level, the foundational law is Forsyth County v. Nationalist Movement that basically says you can't charge a variable fee based on the viewpoint or the anticipated reaction of what that viewpoint may bring. Recently passed Oklahoma Senate Bill 1725 that allows institutions to charge a security fee to a student or a student group for activities that require a permit. But that policy must be content and viewpoint neutral and not based on anticipated reaction to the expressive activities. So, and it also must be published on your website. And we've touched on how important it is to have a really clear policy before you're in the moment. This one is incredibly critical because if you decide you've got a speaker coming that's likely to draw a huge crowd and suddenly you're going to charge a security fee for the very first time, you're going to walk yourselves into a First Amendment claim. So within your policy, you need to think about what objective criteria can you look at. So things like anticipated crowd size based on similar events. Is the venue indoors versus outdoors? So in other words, is it more controlled? Is it a restricted access type of event? Is it ticketed versus non-ticketed? Because then you can control the size. You should also consider publishing general rates for additional law enforcement or other services you might need. If it's an outdoor event where you need to rely on county or multi-jurisdictional resources, such as having Overwatch, if you've got an outdoor area with lots of high points that an individual could target from. So consider that and make sure you keep them updated if you do that. But the biggest key here is making sure that you are implementing it consistently across the board. Doesn't matter who it is or what the speech is, you're using it consistently. What we really like to see here, and what I think our student affairs folks do a really great job at, is working with the student groups on the front end to work with these invited speakers through security logistics. Some groups are really sophisticated. They travel with their own security. They do lots of things. Others aren't so much. And so when you raise those concerns to them and say, how about a different venue that might be a little bit easier to control, a more cost-effective type of security issue for you? So having those conversations early, but touching on Mackenzie's point early, making sure that those conversations from the institutional side don't appear as you're discouraging the speech. That's not at all what you're doing. You're trying to accommodate the speech, but you have to be really cautious of how you do that so it doesn't come across as pricing them out because of security concerns.
So a common theme that I'm hearing from both of you is ad hoc is not a good idea. Things should be planned out ahead of time.
Yeah, if you do nothing else today, have a good policy and follow it.
Mackenzie, can programs impose speech-related standards tied to professional codes of conduct? And as a follow-up to that, where is the boundary between professional expectations and protected expression?
So public institutions have a legitimate interest in preparing students for licensed professions. Think nursing, counseling, social work, and other health-related professions. And they have both a professional standard and ethical obligations. But professional programs cannot use that interest as a general license to suppress viewpoints that perhaps they dislike. And the courts have had to draw a line between these two concepts, right? Conduct standards on one hand, behavioral expectations that are tied to professional performance that apply regardless of the content of one's views, and then two, viewpoint suppression on the other hand, using perhaps the language of professional standards to punish or exclude students for holding or expressing disfavored beliefs. And there are two controlling cases on this issue, Keaton versus Anderson and Ward versus Polite. Unfortunately, neither are in the 10th Circuit, but when we read them together, the courts are saying professional standards need to be tied to observable professional behavior in a clinical or field setting, not to the content of a student's privately held views or off-campus expression. And often this arises in assessment rubrics, right, that evaluate whether a student in a clinical placement treats clients with dignity, communicates without bias, and completes required tasks competently, all of which are defensible, right? In a rubric that evaluates whether a student values or believes in particular things, that's more problematic because you can't assess a belief without compelling its expression. And so the moment of transition from classroom into the clinical setting is where most of these problems really originate. And it's really important for programs and professional programs to be clear about the distinction in their policies so that they don't conflate these two. The most defensible programs are those that are built on a really clear theory about what professional competence actually requires, expressed in behavioral terms, grounded in the licensing body standards, and, as we have now repeated numerous times, enforced consistently, right? Regardless of ideological direction of any individual student's views.
Thank you. Yeah, I'm hearing a lot of common themes here
Right.
on the answers to all these questions. So, Brandee, when going back to protests, when protests shift from general advocacy to focusing on specific individuals, such as administrators or faculty, how should institutions evaluate harassment versus protected speech?
Yeah, this is another one. It's easy to set the foundational principles, a lot harder in practice when you're dealing with it in the moment. So the first issue is it's often difficult to determine who is engaged in the behavior. If it's online in particular, it can be anonymous. You have no idea if that person is part of your institution or not. So that kind of ties back to my earlier answer, and there's some options in that answer. But in general, you need to evaluate the conduct in light of the harassment standard. Is it severe, pervasive, subjectively and objectively offensive, and does it deny access? In addition, here you might start looking at the definition of stalking under Oklahoma law, depending on the behavior. If someone is following a student around, then that could get to a level of stalking. Then look at what exactly is the behavior. Are they chanting and holding signs? That's protected speech. Are they truly following someone around, blocking their access to a building? Then that's unprotected speech. Is it getting to a point where a student is so fearful that they are unable to attend class? Then you might reach that definition of denying access, but it has to be a reasonable fear too. You have that objective and subjective standard. The other issue we've seen a significant rise in is doxing. So posting an individual's personal details. And that becomes a real challenge for the institution to address because the act itself is protected, but what results from that may or may not be protected, just dependent upon the circumstances. And then finally, just is there a true threat involved? And Mackenzie touched on the countermeasure analysis, and it's really imperative to look to that, but it does require a subjective intent on the part of the speaker, and so it's really challenging to prove. But we always encourage, if there's a legitimate fear by anyone, go to law enforcement. Let them take a look at that. We can address it on the institutional side.
Thank you. We're getting close to the end here. I've got one question left for each of you. Although when I say one question, that's usually two questions. So, Mackenzie, when do institutional programs or classroom requirements risk becoming compelled speech? And you might talk about what compelled speech is, and how should institutions structure, for example, history and civic programming to avoid First Amendment challenges?
So the compelled speech doctrine is rooted in really two cases, West Virginia versus Barnett, a Supreme Court case from 1943, and extended in cases like Woolley versus Maynard in 1977, which prohibit governments, like public institutions, from compelling individuals to affirm beliefs that they don't hold. In the institutional context, the key distinction is between teaching content and compelling affirmation. A history or civics course that requires students to learn, say, the text of the Constitution, or the causes of the Civil War, or the arguments made by Federalists and Anti-Federalists is not compelled speech. That's the transmission of knowledge. The critical legal test is whether the requirement compels expression of belief rather than demonstration of knowledge. Students can be required to explain, for example, why the founders believed that they believe without being required to agree with it. So I think there are a few practical structural safeguards like framing learning objectives around civic knowledge and analytical skills rather than personal belief formation. So for example, students will be able to explain the constitutional arguments on both sides of whatever, right? Seems defensible. Whereas when we say, for example, a learning objective of students will develop a commitment to a certain thought, right? That's not helpful. And so in that same vein, when we assess the quality of reasoning, not the direction of the conclusion, and having viewpoint diversity in materials, curricula that exposes students to the strongest versions of multiple perspectives, with a strong focus on primary sources. So I know when Brandee and I have taught classes, we focus on original cases, not secondary sources. For civics, focusing on, say, the Federalist Papers or the debates of the Constitutional Convention, it's much harder to characterize those as ideological than secondary sources with more commentary around them. The most common source of concern is often not curriculum design at the institutional level, but perhaps individual classroom practices, assignment prompts that presuppose an ideological answer, or classroom climates in which students self-censor. This is also where Oklahoma Senate Bill 1725 framework becomes really relevant, right? It creates specific obligations around viewpoint neutrality in the classroom. The founder's vision, in my opinion, for civic education was students who could reason about liberty, not simply recite approved conclusions about it. And so an institution that teaches students to engage seriously with primary sources, evaluating competing arguments on their merits, are the strongest educational programs we have.
Thank you. Well, Brandee, you got the last one. Are there First Amendment considerations when students record or live stream classroom discussions or campus events, and how do privacy laws and academic freedom intersect with recording activity?
That's a really great question with a black and white answer and a less black and white enforcement. So classrooms are generally considered non-public forums. Faculty have the right, or the institution has the right, to restrict recording in class if you can show legitimate pedagogical interests. And in addition, you have potential FERPA privacy concerns. If a student is recording in class and it gets their classmates on that video, that's FERPA protected type of information, or if a student's answering a question. You can have those policies. You do have to have exceptions for ADA though, so make sure you're working with your accessibility folks to make sure that students are allowed to record if that's an accommodation. But you can also restrict even those students who are allowed to record from sharing that information externally, or that video externally, and that is behavior that you can address if it occurs. One of the challenges that we see here is, again, evolving technology, and so students can wear glasses and be recording, and you don't know that they're recording. And I go back to, it's a legitimate fear that faculty have. So now, taking that separate from campus events and public events, students have the right to record all they want. If you're out in the public, there's no expectation of privacy, and students can record those types of situations. And then one of the other areas that is trending, I would say, across public government in general is First Amendment quote auditors that are coming in and recording and using those moments to gain social media attention and following. And while generally there is a right to do that, they also cannot disrupt the activities of the entity. And so I would say in general, a hands-off approach is the best way to go. But if it crosses into physical interference, is probably your highest bar to reach to make sure that you are on safe ground to stop that. But generally speaking, if someone is just recording in general, there's not much you can do about it as an institution, or should do about it.
Well, Mackenzie and Brandee, thank you so much for participating in this Q&A today. I appreciate all that you do for your boards of regents, for your institutions, and for the Oklahoma State Regents for Higher Education and the Oklahoma Free Speech Committee. And for those who are watching this, thank you for participating as well. Good day.